Thank you.
Thank you, Counsel. Last case on the docket is Hobbs versus MIREN.
May I proceed, Your Honors?
May.
May it please the Court, my name is A.J. Stanton, and I represent the appellants in this matter. I, too, Your Honors, have a minor point of order. In finalizing my preparation for today's argument, I noticed some very, very minor nuancial differences between the statement of facts in my brief, which opposing counsel in his answer brief said were true and accurate, and the final judgment, which contains stipulated facts by both parties. I haven't really thought a lot of time on how to correct that other than to perhaps notice the Court by filing a notice if the Court is interested. I don't believe that the facts are relevant to today's proceeding. I think what happened is I might have done a cut and paste on a prior version of the final judgment, and that's why they showed up. But I can file a notice if the Court deems that to be appropriate.
I think if it becomes an issue, you can do it. But
yes, sir.
If not, you don't need to.
Thank you, Your Honor. The issues before this Court today require this Court to give some thoughtful consideration of the role that a Chapter 723 mobile home prospectus and the leases incorporated therein play in the relationship of a mobile home park landlord and its residents. And the ruling of this Court will have effect across the state of Florida. As an officer of this Court, I will represent that an automatically renewing lease in a mobile home park is common. The leases in this place are different from the typical mobile home park lease in two respects. One, they were not 1 year automatically renewing, they were 5 year. Two, they did not provide for a rent escalation, whereas in typical mobile home park leases, you see a rent escalation clause based on consumer price index, market rent, or some other variable that allows for the market rent.
What's the bottom line of your position as to how long these leases will go on?
I have no idea. My bottom line is these are Chapter 723 mobile home park leases.
Is it your position that they can go on in perpetuity?
No, it is not my position. In fact, in my brief, I have acknowledged.
Then how is the term determined?
The term is determined by the prospectus and the legislative enactments of Chapter 723.
And what does that, in this case, with this perspective, what does that mean as to the term of these leases that are in question?
These leases will automatically renew every 5 year period until they are terminated under the minimal provisions of Chapter 723, which could be for non-payment of rent, it could be for change of use of the land, it could be for violation of a rule, but you cannot terminate a Chapter 723 lease. There is no decision in the state of Florida that has ruled otherwise.
Every perpetual lease, which is disfavored by the court, obviously, can be terminated for those sort of things, right? I mean, you can have a perpetual lease, but it can be terminated for breach, it can be terminated for violation of various statutes. That doesn't keep it from being a perpetual lease, correct?
I agree.
And if we disfavor perpetual leases, the defense can't be, this isn't perpetual because it can be terminated for a breach, right?
I agree.
Okay. In which case, your argument seems, since you're saying it can only be terminated for these breaches, you're back to your original position, which was this is a perpetual lease.
Forgive me, not just breaches, but the park owner has the right to change the use of the land and change the lease. The park owner also has a right of first refusal in the terms of these leases to purchase the leases.
Do landlords have that right in non-mobile home context?
Of course.
So the cases that complain about or that disfavor perpetual leases would have that same defense,
absolutely,
right?
But what I want to do here today is make the point that the issue of perpetuality is not before this court, unless the court is prepared to rule that Chapter 723, as it is enacted, favors perpetual leases.
It's before this court, at least to the extent that the law of the case in this case is that these aren't perpetual leases, right?
That's correct.
So you can't take a position today that results in them being considered perpetual leases, correct? Because you've already had that day in court and lost.
That's not necessarily true for one reason. The law of the case in this court, before this court, is not binding to this court because two items were different from the prior appeal. We had a motion for summary judgment before the last trial court. The evidence before the trial court at trial included the prospectus. That was not before the court at the motion for summary judgment. And the prospectus is what dictates the relationship of a landlord and a tenant in a Chapter 723 park. So according to the authority that I cited in my brief, the law of the case does not apply in this case. Number two, the issues were different. In the first appeal, the appellant took the position, and the defendants in the trial level, took the position that the trial court erred because these leases are perpetual. This court did not, this court ruled, in its opinion, we conclude that the disputed leases cannot, as a matter of law, be construed to be perpetual. That was without the evidence of a prospectus before the court and without the benefit of the argument that results from the existence of a prospectus. Opposing counsel in their answer brief has not addressed the relevance of a mobile home park prospectus in this particular case. And that's something that the prior court, the prior 50 CA bench, did not have the benefit of consideration either because, again, it was not yet introduced into evidence. We were at the motion for summary judgment level.
But the prospectus was in existence prior to the first action by the trial court in the first appeal, correct?
Absolutely. In fact, the prospectus was recorded many, many, many years ago. I think there have actually been several revisions to it. The issue...
Your position that the prospectus is part of the lease?
Absolutely. Well, no. The prospectus is the document by which, as in fact I noted, Chapter 723.113, which states that a prospectus, together with its exhibits, is a disclosure document intended to afford protection to homeowners and prospective homeowners in the mobile home park. The purpose of the document is to disclose the representations of the mobile home park owner concerning the operations of the park. And in subsequent sections, it states what a mobile home park prospectus must include, one of which is the leases that you're going to offer to the public and the terms by which those leases can be adjusted. So to answer your question, Judge Palmer, and I apologize for the delayed response, the prospectus is the disclosure document. Incorporated into it are the leases which also act as part of that disclosure.
The lease is incorporated into the prospectus, not the other way around.
That's correct.
So the prospectus is not part of the lease.
I would take that position.
So if the court is to interpret the meaning of a lease, they wouldn't necessarily have to take into consideration what's in the prospectus unless they first determine that the lease is ambiguous and you have to go to parole evidence, and part of the parole evidence might or might not be the prospectus.
I think
right?
that's a difficult thing because if the lease is a part of the prospectus and the disclosure document by which your tenancy is in part operated, it would be awfully difficult to separate the two. I do believe they have to be read together. This was an issue, by the way, that the Department of Business and Professional Regulation, which, by the way, again, there really has been no decision in the state of Florida that have particularly addressed this issue. I think perhaps park owners and residents alike don't like this subject. The Department of Business and Professional Regulation case that I cited in my supplemental authority, the facts in that case are very simple. There was a P1 prospectus, which is the first prospectus that's filed when a mobile home park, Chapter 723, is created. There was an amendment to it, and then there was a P2 prospectus. Now, these first three prospectuses had provided for automatically renewing one-year leases and rent escalations based upon the consumer price index. Subsequently, the park owner created a P3 prospectus with a rent escalation based on consumer price index or market rate, which would provide for perhaps a higher increase in rent. It also provided for a lifetime tenancy. Now, what the park owner sought to do was, his position was the leases, since they automatically renew once a year, then at the end of that renewal period, the lease terminates. And I can impose a new prospectus and a new lease on existing residents as well as those that buy into the park. The Department of Business and Professional Regulation acknowledged that the issue of when a tenancy expires in a mobile home park is one that really hasn't been answered by any court in the state of Florida. And I think it was a first district decision that they noted struggled with the issue, and that decision stated that this is an issue for the legislature to resolve. And what they did is the Department of Business and Regulation fell back on a plain reading of Chapter 723.059. And the department ruled that the buyers of existing lots are entitled to rely on the prospectus and lot rent agreement attached thereto that are delivered to the initial lot owner. The initial prospectus governs the manner in which a park owner can increase a buyer's rent upon expiration of the lease term. Now, the park owner in this case was arguing this is unfair. It's a covenant running with the land. I would argue, in effect, it is. It attaches to that lot and it doesn't leave it unless a new tenant coming in agrees or consents to accept a new prospectus. I want to point out that Chapter 723.032 subsection 1 provides that a mobile home lot rental agreement may provide a specific duration with regard to the amount of rental payments and other conditions of the tenancy, but the rental agreement shall neither provide for nor be construed to provide for the termination of any tenancy except as provided in section 723.061, none of which those provisions are relevant here. This subsection 2 to 032, I think it should be brought to the court's attention, provides that any provision in the rental agreement is void and unenforceable to the extent that it attempts to waive or preclude the rights, remedies, or requirements set forth in this chapter arising hereunder. These arguments weren't made to the trial court other than this issue of perpetuality. And if the court is concerned that these leases are unenforceable as being perpetual, again, we need to turn back to the legislative provisions. Now, this court in its prior ruling stated, and it was only addressing 723.059, it stated that there is nothing in the statute, and the court was addressing 723.059, nothing in the statute which suggests a legislative intent to modify the common law requirements for the creation of a perpetual lease. Again, Judge Palmer, to your point, if your concern is that this is a perpetual lease, I have outlined in my brief numerous examples of legislative intent relating to the prospectus, which was not before the trial court or this court previously on the motion for summary judgment, that do show that intent, that do show that a prospectus is the document, along with the leases incorporated in it, that dictate the relationship of the parties, the rights of the park owner to change the lease, to increase lot rents, and so forth and so on.
Wait a minute, I'm confused. Are you now arguing that it is a perpetual lease, but it's okay because it's crystal clear it's perpetual when you
to the extent that this, I'm not arguing that it's a perpetual lease. I'm addressing your Honor's point that if you believe that it's a perpetual lease and it's not enforceable, the prior bench, the prior court, the prior appeal addressed in their opinion that there was no legal authority to suggest of the legislature that any common law issue regarding perpetual leases had been changed. And in the new, on this appeal, with the additional factual evidence concerning the existence of a prospectus, that point should be changed. The legislature has made it clear, and this is just addressing your point, that if the court believes that this lease is unenforceable as a perpetual lease, the legislature has made it clear, I've cited authority relating to the prospectus, that they are enforceable. Call them what you want. They are enforceable. This is what a mobile home, this is how a mobile home park operates.
Let me make sure I understand your position.
Yes,
your
sir.
position is it is not a perpetual lease because A, the landlord could change the use of the property, or B, the tenant could do something which could lead to them being terminated. Are those the only bases on which you're contending that this is not a perpetual lease?
That and the fact that it's been specifically endorsed by Chapter 723 in the legislature. That the issue of perpetuality is not before this court. The question is, are these enforceable
by the
leases?
statute?
I'm sorry?
What has been endorsed by the statute?
The
The idea of perpetuality?
Well, Your Honor, no. The idea that these leases are enforceable as they are worded. Just as the Department of Business and Professional Regulation struggled with the issue, as worded, this is the nature of a mobile home park lease. Stewart v. Green's Supreme Court decision outlined very clearly that this is a unique...
Oh, but didn't we already rule in the first round that as written, it doesn't provide for that?
I'm sorry?
You just said what the statute says is that these leases are enforceable as written.
Right.
And in round one, we decided that, in fact, this lease as written didn't provide for perpetuality, right?
I must not have made my point clear. In round one, you did not have the statutory authority that I have cited to this court, and the reason you didn't have it is because you didn't have the prospectus and evidence. It was a ruling on a motion for summary judgment. We went back to trial. We submitted additional evidence for the trial court's consideration, and the argument of the relevancy of a prospectus in this particular appeal. That's the difference. And as a result, this court now is armed with the additional authority relating to a prospectus to rule that's the way it works in a mobile home park. You can't change that. And if this court were to find that these leases are unenforceable as perpetual, then it is in effect indicting every single mobile home park lease in the state of Florida. You will have park owners at the expiration of an automatically renewing lease seeking to go to their residents and say, you better sign a new lease, I'm going to change your prospectus, or you're going to get out of the park. My second issue is very simple. Assuming that, the issue for the trial court was to decide, well, if they can't be enforced as perpetual, what are they? And I do want to make one more point before I move on. The issue of perpetuality was not raised by the complaint filed in this case. It was raised by the defense. It was raised in their counterclaim. It was raised in their answer as a defense. The issue, the trial court still had to consider, if they're not perpetual, what are they? The trial court has now ruled that the leases, based on the Schroeder decision before this court, that they will terminate after 2 renewals. The effect of that ruling was to find that they terminated during a period in which a prior park owner owned the park and had acknowledged the validity of these leases. I have a problem with that, because not only did it terminate it during a period in which someone else owned the park as opposed to the current owner, where did it leave us back then? In effect, is retroactively canceling out the time period in which someone affirmatively acknowledged the existence of the lease. We need a point to start. Where are we? What are the terms of this lease? What are the rents going to be? The trial court in its ruling effectively stated, you are now a tenant by acquiescence. Again, in a Chapter 723 situation, you can only occupy a lot based on a prospectus and a lease that's been filed with the Department of Business and Professional Regulation. If the trial court is going to effectively modify or create a new lease, that lease has to be filed with the Department of Business and Professional Regulation. You can't have a tenancy by acquiescence in a mobile home park. It's impossible. And these are issues, again, I see that I have 2 minutes left, issues that again, the one big point is the existence of the prospectus, something that the appellee himself has not addressed in this entire appeal. What is the relevance of a prospectus in a mobile home park? Thank you.
Thank you.
May it please the court, counsel. I'm David Glasser. I'm the counsel for the appellee in this case. That's the MIREN International Lodging. I think the court's asked a lot of questions. I'll be well versed in this issue. We came before this court several months ago to determine the status of these leases. The court specifically indicated there was inadequate language in the leases to determine that they were perpetual. So what happened? We went back to the trial court. The trial court had an issue. If they're not perpetual, how long are they? And obviously, the issue here is whether the trial court erred as a matter of law in the trial court's decision. We went before the trial court. The trial court, in my opinion, not only my opinion, but I think legally, issued a well-reasoned opinion as to what the determination was as to the length of these leases. The trial court cited this case, which we presented, that Schroeder case, which clearly indicates that if you have leases, and it states that they're automatically renewable every 5 years, okay, and they're not perpetual. Generally, the courts look at either 1 or 2 5-year renewals, which means these leases were from the early 1980s, 82, 83. It's 2 5-year renewals. The leases would have technically ended in the late 90s. If the court recalls, my client didn't purchase this property until 2004. So the previous owner had the case. Now, the court looked at all of that, and the court said, if the leases are not valid at that point, then what happens to the leases? The court stated, the court didn't say they're not invalid. The court just looked at Chapter 723 of the Florida statutes, reference to mobile homes, stating that generally the minimum term for a lease can only be 1 year. The court stated by acquiescence, the prior owner and the appellants, that they kind of agreed year by year by year. They're kind of acquiescence year by year. They're 1-year leases. Until my client purchased the property, then the court looked at it. If my client purchased the property, if he wants the appellants to have a lease because they know how to have a written lease, what does my client have to do? Just to go to Chapter 723 of the Florida statutes, the law, and state my client has to follow the law in having the appellants not only enter into leases, but also if he wants to increase the rent, etc., he just has to follow the statute. We claim that all of this reasoning by the trial court is clearly supported by the law. It's supported by this court's decision in the prior case where the court found the leases were not perpetual. I think, obviously, my opponent hasn't answered the question. If they're not perpetual, how long do they go? They go on and on and on until technically they're terminated. They raised a couple of issues here, which I want to address with the court. I think the public policy issue, I think, was addressed previously. They're trying to distinguish the Chapter 723, stating because people in mobile home parks, they build their properties, they attach them to the land, etc. If their leases end, they have to pick up, etc. In this case, that policy will not apply here because, first, this is an unusual situation where the leases were determined to be invalid. Nobody has terminated the lease as they've indicated. I think there's a difference here. Terminating lease versus terminating the tenancy. Terminating a tenancy is an eviction. Somebody doesn't follow the rules of the park, they don't pay their rents, they don't follow by the rules, the statute is clear. It's a well-written statute, 723, they're convicted of a felony, then their tenancy can be terminated. They're stating that if we terminate this, this is not that kind of a case. The trial court went out of the trial court's way not to terminate. They said the leases were not invalid. This court ruled the leases were not valid. The trial court ruled the term of the lease. The trial court didn't terminate the leases. The trial court, in fact, stated, you don't have to leave, just follow along with Chapter 723 of the Florida statutes. Nobody has asked the appellants to leave, not at this point, but obviously that the statutes clearly indicate the time frames when what has to be done in order for them to enter into a valid lease. So in that regard, I think the trial court's decision was a well-reasoned opinion. Secondly, I just want to address this issue with the prospectus. I think the statute clearly indicates that a mobile home park has to submit a prospectus. And clearly, it's a notice to all of the tenants of the mobile home park as to the policies and procedures of the park, how they can charge utilities, rent increases, etc. Okay, they're arguing that this document is binding. Now, their argument clearly, there's nothing new on this prospectus. This prospectus has been in existence since the early 1990s. Now they're bringing this up. They're saying we didn't bring this up to the trial court. Clearly, this is an issue, they were going to bring this up as far as perpetuity, they should have brought it up before, rather than bringing up the same issue now all over again, saying, okay, here's the prospectus now, we're bringing it up all over again to argue that the leases should not be ended. But aside from that, a prospectus, it's read in conjunction with the lease. Even in their document, the prospectus, even in their document, they cite the law. The prospectus is as good as as long as the tenancy. If the tenancy, technically, if the lease was only valid with the 2 5-year renewals up until the end of the 1990s, then the question is, and again, this has not been, I'm not saying there's any case law on this, but technically the prospectus is still in place, but they're arguing it still goes on, but that's contrary to ruling that the leases are not perpetual. It's contrary. You know, the prospectus is a supporting document. It's not, we can tell you this is not the binding document here. The real binding document is the lease itself, which that's what everybody signs. But I want to go...
Does the prospectus in essence say we've attached a lease and this is the lease that we use?
That's correct. The leases have to be attached along with this prospectus and filed with the state. Yes, Your Honor, that's what has to be done. You know, they provided some supplemental authority, which is interesting, but that case is clearly distinguishable. You know, in that case, there were lifetime leases. There were 3 separate prospectus. And the prospectus said it automatically renews, it's assumable, etc. And the landlord in that case, or the mobile home park owner, stated that if someone that would assume the lease at some point would have to, they would have to sign a new lease under the 3rd prospectus that was entered on there in the court. And basically, the opinion of the administrative agency was not the case, that the 2 prospectuses earlier were binding. That's a different case than here. There's no issues there of any perpetuity, whether the lease itself was valid or contrary to public policy. I think probably the court there sounds like they made a good opinion, but that case is not, that's really not on point here. That they didn't deal with the leases there being invalid, etc. And I just want to address their issue here. You know, they're alleging that the trial court stated that these leases, that the decision is wrong because the trial court terminated the leases and they can only be terminated under certain provisions of the statute. Again, the trial court just ruled, they didn't terminate the lease, they just ruled on the length of the leases clearly supported by the Chessmaster case and the Schroeder case that I cited in the brief. The statute is very clear. Okay, I just want to clarify this issue. The statute is clear that a lease itself cannot have provisions to terminate the tenancy, except under the specific eviction procedures here. And again, it's a well-written statute. You can't put in there that a lease can be terminated for a reason that's other than in the statute. And for eviction proceedings, we're talking about terminating. We're really talking about eviction. You don't pay your rent. You don't. You're convicted of a felony. You don't follow the park rules and regulations. You can't have in the lease a provision in there that the tenancy can be terminated other than those reasons, which is good. And that clearly is for the public policy reasons, so people don't be uprooted, from their homes that they've built that are attached to the land, etc. The trial court didn't. That's not the issue here. Again, I keep coming back to that. The issue is that the leases themselves, there's a 2-term renewal. The court could have even said a 1-term, but the court went with 2-term renewal on that, and that is really the basis. Basically, we're claiming that the trial court's opinion was clearly not only supported by the law, but clearly the trial court carefully took into consideration this court's decision in the prior decision in reference to whether the leases were perpetual. So we're claiming that we're asking the court to affirm the trial court's decision at this point. I have nothing further.
Thank you.
I do want to make clear that the trial court did terminate the leases. I cited it in my reply brief. specifically held the leases terminated, which left the trial court with an issue of, if they're going to terminate them, where does it leave the parties? And I've stated why I believe it's improper to find that they terminated back during a time period when someone didn't even object to them. Justice Palmer, you asked about the prospectus and were the leases attached. Yes, the specific leases in question were attached, not by name, but the terms 5-year automatically renewing were attached to the prospectus filed with the Department of Business and Professional Regulation. The DBPR ruling is directly on point. It specifically is an endorsement of the concept of an automatically renewing lease in a mobile home park. There is simply no other way to put it. That the prospectus is a disclosure document. It's a 723, as well as the Supreme Court Stewart versus Green opinion have stated that 723 leases are unique situations. It's the only situation where you find your house on someone else's land. The concept of movability, like in an apartment, is not present. You have a much more vested interest. So when you pay substantial sums of money, like my clients did, $10,000 for a no-rent lease provision, they expect to be able to have some degree of permanence, much like any other mobile home tenant around the state of Florida. And finally, again, I draw back to this court's prior ruling. They were only talking about 723.059 subsection 5 relating to lifetime leases when they held that this section shows nothing which would suggest a legislative intent to modify the common law requirements for the creation of a perpetual lease. This court did not have the prospectus before it. It was on appeal on a motion for summary judgment. The prospectus was not before the trial court. It was not before this court. And the statute supporting the concept of a prospectus was not an issue. Thank you so much for your time today.
Thank you, counsel. Court will be in recess.